Hello dear student, I am CA Preeti Agarwal, your law teacher, and today in this video we are going to discuss classification of company on the basis of liability. Now on the basis of liability, companies are classified as company limited by shares, company limited by guarantee and unlimited liability company. So we are going to discuss all these three types of companies with the help of charts and my notes. After this video, you will gain immense clarity on this concept. The companies may be broadly classified on the basis of members, liability, control, and access to capital. Let us now discuss the classification on the basis of liability. Whenever we discuss liability, we are talking about liability of the members, which may be either limited by shares, guarantee, or it may be an unlimited liability for them. We are not discussing liability of the company. Liability of the company is always unlimited. Yes. So let us write a small note over here. Whenever we talk about liability, we are discussing the liability of a member, which may be either limited or unlimited. It may be limited by shares or by guarantee. So whenever we discuss about liability, we are actually talking about liability of the members. Liability of company is always unlimited. Okay. Liability of a company is always unlimited. So please note this also. Whatever we are discussing is from the member's point of view, not company point of view. Done writing? Okay, let us discuss the table now. Classification on the basis of shares. In this case, my liability is limited to the amount unpaid on shares, or in other words, my liability is limited to the face value of shares. Let's say that the face value of share is 10 rupees. I have paid up 6 rupees. So what will be the liability of member? It will be only 4 rupees per share. So liability will be rupees 4 per share. Can I ask him to pay 7 rupees, or can I ask him instead of face value 10, you pay me 15 rupees? No. My liability is limited to the face value of shares. I will not pay more than 10 rupees. You can also say that the liability is restricted to the amount unpaid on shares. So both ways are correct, but please remember that we cannot ask the member to pay more than the face value. When can I call this amount? Okay, now face value is 10. When can I call this amount? You can call it anytime. During the lifetime, at the time of winding up, whenever you require money. So let's say that at the time of allotment, I called 6 rupees. Then the remaining 4 rupees I can call anytime. At the time of during the lifetime, whenever I need money, I can also call it at the time of winding up. The member is liable to pay 10 rupees whenever demanded by the company. Now, who will decide how much amount is to be called? Board of directors. So board of directors of the company will make calls and the shareholders will contribute that money whenever demanded. Okay. What about company limited by guarantee? In this case, the liability of members is restricted to the amount they have guaranteed to pay at the time of winding up of the company. Generally, Section 8 companies, non-profit organizations, they are all incorporated as a Section 8 company. See, during the lifetime, they don't need money because they get a lot of money from donation, charity, subscription, admission fees, etc. It's at the time of winding up that they need money to pay the creditors. So this company tells the members, see members, I don't require your money during the lifetime because I get a lot of donation, charity, subscription money. At the time of winding up, will you please help me? So I went to Mr. A, who is member of the company, and he assured that he will pay 15,000 rupees. I said, guaranteed? Na? He said, yes, guarantee, I will pay 15,000. I went to Mr. B. He assured me that he will pay 30,000 rupees. Mr. C guaranteed to pay 50,000 rupees. So I made a list of the contributions that these people will make at the time of winding up. Such type of companies are known as companies limited by guarantee. So in case of guarantee companies, members agree to contribute money at the time of winding up. But it is possible that they may have share capital, which we can call during the lifetime. They may not have share capital. Let us discuss that also. So guarantee company is a company in which the liability is limited to the amount of guarantee which we will receive at the time of winding up. Now these companies may have share capital, they may not have share capital. Like I already discussed with you that during the lifetime they get a lot of money from other sources. They don't need shareholders' money from the share capital. So they say that we don't want your share capital, you only help us at the time of winding up. So how much are you guaranteeing to pay? So these companies may not have share capital. In that case, there will be only one liability of the member, which he will pay at the time of winding up. But sometimes these companies may have share capital because they realize that we need members' money also, So these companies may also have share capital. In that case, there will be two liabilities. One is the amount unpaid on shares, which can be called up anytime during the lifetime. And the second amount will be the amount of guarantee. This is the second liability, which can be called up only at the time of winding up. So these companies may have share capital, they may not have share capital. If they don't have share capital, there is just one liability. If they have share capital, then they are liable not only for the amount unpaid on shares, but also for the amount of guarantee. We may also have unlimited liability company. Now, I don't understand why unlimited liability. See, anyways, you are a company. Limited liability is one of the most important characteristics of a company. Why incorporate a company with unlimited liability? Basically, these type of companies are incorporated to give greater assurance to the creditors, something which I discussed with you earlier. So as a company, I want to give greater assurance to my creditors by telling them that don't worry, even if the company goes into winding up, you will be paid your money. The liability of members is unlimited. So it is to give greater assurance to the creditors. This is from the company's point of view. Company is working in an industry wherein limited liability is looked down upon. It is frowned upon. So I may give more assurance to the creditors that don't worry, that my liability is unlimited. Even if the company doesn't have money, members will bring it from their personal asset. Why will a member want to invest in an unlimited liability company? Member is not worried about the solvency because they have a lot of confidence in the company. The company has a good will. It has a good name in the market. I don't think it will be wound up so soon. And anyways, who's going to stay till the company winds up? No, we'll sell and liquidate our shares. So from the members' point of view, investors' point of view, they don't think that the company will go into liquidation. And even if it does, who's bothered? We'll see when the company goes into winding up. Why worry about it now? Now, in case of unlimited liability company, the liability is not always unlimited. During the lifetime, they get to enjoy limited liability. It's only at the time of winding up that the liability is unlimited. We'll see when the company winds up. Why worry about it now? So at least during the lifetime, they get to enjoy limited liability. That is why they are not worried. So the entire concept of classification on the basis of liability is covered here. Now let us read all this from the textbook and I will make you write certain extra notes also. So these are companies which are classified on the basis of liability. I have Company Limited by Shares, Section 2, Clause 22. Company Limited by Shares is a company in which the liability of the members is limited by the memorandum. Okay, so the liability clause is mentioned in the memorandum. I'll just adjust my mic a little. Yes. So in case of Company Limited by Shares, where is the liability clause mentioned? It is mentioned in the memorandum. So the memorandum will mention whether the liability is limited, whether it is limited by shares or guarantee. So the liability of members, I'll highlight the keywords, you do it along with me. The liability of members, okay, we are always talking about liability of the members because company's liability is always unlimited. Liability of the members is limited, where by the memorandum, to the amount, if any, unpaid on shares, because it is not compulsory that you may have unpaid amount on shares. You may be holder of fully paid up shares. In that case, you have no liability towards the shares because you've already paid the face value. So it is written if any, that is if the amount is unpaid, that is your liability. Liability, when can we call that unpaid amount? You can call it anytime you want. Either during the lifetime, it will be called by the directors, or you can call it at the time of winding up. At the time of winding up, it will be called by the liquidator. So that unpaid amount, like in my example, the face value was 10. I had called and paid, people had paid 6 rupees. So now 4 rupees, okay, rupees 4 is the unpaid amount. This can be called up anytime, either during the lifetime or at the time of winding up. Now, who will decide what is the amount to be called up? Directors will decide. See, whenever they need money, they will call it. Is it compulsory to call the entire 4 rupees now? No, you decide whatever amount you require, you call that much. So it is left to the discretion of the directors. They can call it whenever they are in need of money. The companies may be either private or public, because we know this is the main classification. Okay, so private and public is the main classification. Then you have category, that is company limited by shares, guarantee, unlimited. Then subcategory, whether it is a government company, non-government, foreign, domestic, holding, subsidiary, that is a subcategory. When the initial working capital, it falls short, then the directors have the right to call, that is demand from the shareholders, the amount which is unpaid. That is unpaid of the nominal value. Nominal is nothing but the face value. So out of the face value, whatever is unpaid, that can be called. See, it is worth noting that both the time for the amount of call, they are uncertain. We don't know when the company will require money. We don't know how much money is required by the company. Whenever you require money, call for it. It is left to the absolute discretion of the directors. It is left at their will. They will decide how much amount is to be called. Then let us discuss companies limited by guarantee. Okay, we have guarantee companies, section 2, clause 21. Now, this is a company in which the liability of the members, again, we are talking about liability of the members. So, liability of the members. It is limited. How? Liability clauses mentioned in the memorandum. So, it is limited by the memorandum to the amount that they have guaranteed to pay in the event of winding up. So when will I receive that money? Winding up. They don't need initial funds from members. Why? See, I already informed you that these guarantee companies are generally Section 8 companies. So they get a lot of money from endowment, fees, charges, donation. They get a lot of money from there. So they don't need initial working funds from the members. They don't need their share capital. No working funds are required because they get a lot of money from endowment, fees, donation. Now you know what is the meaning of donation. Charges they may collect, maybe you're using the pool, or you're using services like the canteen, or you're using services like the recreational room, you're playing table tennis and etc. So you need to pay nominal charges like 100 rupees, 50 rupees. It's a club. Okay, I have a club and I charge the members nominal fees for using these facilities. So those charges, that is my income. I get fees like subscription fees, admission fees. Endowment, what is endowment? Now, let's say that every year I need money for my annual function. Okay, I conduct an annual function every year and I need money because on this day there are many races, and I have a special event for physically challenged or mentally challenged children. We give away prizes, trophies. We have a free lunch for all the members of the club. Everything requires money. And, it's an annual event. Every year I know I'm going to require money. So what I do is I invite donations. I invite people to give money so that we can conduct this annual function. But I can't ask money every year, right? So I tell them that you give money. I will use it for annual function every year. So in the first year, I asked people to donate and I managed to collect 10 lakh rupees. But every year, I'm not going to spend 10 lakh rupees on the annual function. And annual function is going to happen just once in a year. I don't need this money every month also. So what I do is I create a fund. Okay, I create a fund. I create an endowment fund. Why am I using the word endowment? Because this fund is used for a specific purpose. Okay, so I create this fund for a specific purpose. It's not a general fund. I can't use this money for general purposes like repairing, etc. I have raised this money for some special purpose. What is the special purpose? Every year I'm going to use it for annual function. Since it is for a specific purpose, for a special purpose, this fund is known as an endowment fund. Do I need this money every month? No. Why should I keep this money idle in the bank? Invest it. Against this fund, you will have endowment fund investments. See, even sinking fund is a kind of an endowment fund because it is for a specific purpose, and you have sinking fund investment. Provident fund, you have provident fund investment. So please remember, students, that whenever a fund is created, you will always have investments against it because you don't require the fund money immediately. You don't require it every year, every month. So why keep it idle? Like provident fund, I need to give only when the member retires, no? When that employee retires. So instead of keeping it idle for so many years, I invest that money. So whenever we have a fund, you will always have investments against that fund. So I have an endowment fund. I will have endowment fund investment. Now, these investments yield an interest of, let's say, 1 lakh rupees per year. That is sufficient for me. I can organize the annual function and spend 1 lakh on it. How much will I spend on prizes? No. And lunch also, how much will people eat? So 1 lakh is sufficient. Now, what is the advantage of investing that money and utilizing the income earned from that investment? See, there is a lot of advantage. If I start using the fund, there will be a point when 10 lakh rupees will get exhausted and I'll have to ask people for money again. But instead of using that fund money, what if I use the earnings from that fund? Okay, the interest which I earn every year, the money that I earn from the investments, if I use that for the annual function, my fund remains intact. And every year I also have money for that event. So money remains intact and I use the income that I earn from that investment for the activity. That is the use of endowment fund. Okay. So I will not use this fund money. I will use the earnings from that fund for fulfilling my annual function obligation. So this is endowment fund, money which I have used. So I have money to carry out my yearly obligations. I don't need your share capital. I get a lot of money from these activities. So that is the endowment fund. It is for a specific purpose. Guarantee company may be either private or public because this is the main classification. It may or may not have share capital. I am aware of that. In case of company limited by guarantee, the amount to which each person contributes shall be towards the assets of the company. Now, every person has guarantee to give certain amount. What will happen? See, when we liquidate, when the company goes into winding up, the assets will be sold and the liabilities shall be paid off. But because you have guaranteed, if the liabilities are more than what money I have, so I will tell you, see, you had guaranteed, now you will pay. Please pay me money. I don't have that much money to pay off my liabilities. So Mr. A, B, C, they will all contribute whatever they have promised. So I will use it towards the assets of the company. It means I will use that money to pay off my liabilities. Now Mr. X transferred his interest to Y. And within 6 months of this transfer, the company went into liquidation. So the company went to Y and they demanded, see, X had given a guarantee. And now that you have purchased the shares, you will have to pay that money. Y says, I'm not in a position to pay. I don't have money. Since the winding up took place within 1 year of transfer, instead of Y, we can hold X liable. See, you had transferred your interest to Y. If Y is not paying, you will have to pay if the winding up takes place within 1 year of transfer. So you remain liable as a contributory for at least 1 year from your transfer. If the winding up happened beyond 1 year, then X will not be liable, Y will be liable. And if we are not able to recover, then we will ask the other members to pay, and then later on recover it from Y. So you are liable towards the assets of the company in the event that is wound up while he was a member, or within 1 year after he ceases to be a member. But will you be liable for all the liabilities? No. If the winding up takes place within 1 year of my transfer, I will be responsible only for the liabilities incurred while I was a member. So company had taken loan or company had incurred certain expenditure while I was a member. I I have transferred the shares and the company goes into liquidation. Then in that case, X will be liable, but only to the extent of liabilities which were incurred while he was a member. I will also contribute towards the cost, charges, expenses. It means whatever amount that I'm paying will be used to pay off the liabilities, but it will also be used to pay off the cost, expenses, charges of winding up. For adjustment of right among the contributories themselves. So let's say that A, B, C, they are contributing. C has paid more than his share. Why? Because A couldn't pay. So later on, C can recover that amount from A. You can adjust your rights if you have paid more than your liability. So you just need to memorize these 3 points. Then we have unlimited liability company. The most important characteristic of a company is limited liability. Here we are foregoing that and we are instead going for unlimited liability company. As far as the company is concerned, I already discussed with you. This unlimited liability company gives greater assurance to creditors. Okay, it gives greater assurance to creditors. Creditors don't want to work with a company having limited liability. I'm operating in an industry wherein people want to work with unlimited liability. They want greater assurance that their claim will be satisfied, they will get money. All right. From the members' point of view, I discussed with you that members are not worried that the company will go into liquidation. And even if it does, who's planning to stay till there? I have examples for you. I have examples of guarantee company. I have examples of unlimited liability. I will show it to you later. Let me first discuss the concept with you. Now, what happens in case of unlimited liability? See, you need not worry because during the lifetime, members enjoy limited liability. It's only at the time of winding up that the liability is unlimited. Why worry about that now? At the time of winding up, what will happen? See, we don't wait till winding up. These creditors insist on winding up of the company. So these creditors, okay, these are my creditors. They will apply to the court for winding up. They will apply to the court for winding up. They will go to the court and they will prove that the company is unable to fulfill their obligations. Please wind up the company. So creditors, they will apply for winding up to the court. The court, if it is convinced, the court will then appoint a liquidator. The liquidator will sell assets. They will try to pay off the liabilities. If they fall short, they will remind the members. Okay, they will remind the members that, members, listen, your liability is unlimited. Pay money. So these members will then pay money to the liquidator. Liquidator will pay money to the creditors. Why go through all this? Creditors should have directly filed case against the members. That's not possible. The creditors have a contract with the company. Creditors have no contract with members. In fact, over here, members are stranger to contract. So creditors cannot file case against the members because they don't have a contract with members. Creditors have a contract with the company, so they will file case against the company. So company will recover money from the members and then give it to the creditors. Okay, so that is why we can't file case directly against the members. So you can write all this if you want. Done? There's something wrong with the screen, I think. Okay. So this is the notes that we have taken. It is a company in which the liability of the members is not limited by the memorandum. They may be required to pay the company's losses from their personal assets, all right, personal property. So long as the company is a going concern, it means during the lifetime. Liability on shares is the only liability which can be enforced, but it is always unlimited as far as the creditors are concerned. Such companies, they have separate legal status, therefore the creditors cannot file case against the members. Creditors will apply to the court will appoint a liquidator, the liquidator will recover money from the members, give it to the creditors. So whatever was written, I have explained that in a chart form. So students, these were the classifications on the basis of liability. Now let us discuss companies classified on the basis of control. Before that, these are few examples of company limited by guarantee. If you notice something, not all of them have the word limited or private limited at the end of their name. So here we have RM Milk Producers Association Limited, Ashok Oil Industries Limited, but here we have Dr. Reddy's Research Foundation. These are all Section 8 companies. Section 8 companies need not add the word limited or private limited at the end of the name. It is one of the privileges given to Section 8 company, yes or no? So their name will end with the word foundation, federation, council, etc. These are Unlimited Liability Company, Edge Information Systems Private Limited, Reebok India company, yes, Reebok India, it is a subsidiary, it is having unlimited liability. You can also go and check their details on MCA's website, mca.gov.in. Go to master data, enter their name, you will be able to see the entire information about the company. When was it registered? What is the category, subcategory, who are the first members, that is subscribers, directors. Rally Wolf, G Money, New Age, these are all examples of unlimited liability companies. So students, I hope you enjoyed today's session. Do let me know in the comment section if you want me to make video on any concept that you're struggling with, and I would gladly make a video on the same. So with this, let us end today's session. For lectures, books, podcast, do visit my website capreetyagarwal.com. My contact number is also mentioned in the description. You can get in touch with me in case of any query, and I'll see you in my next video with another interesting concept.